Hi, everybody. My name is Kathleen Scott. I'm the managing partner at the Scott Wagner Law Firm. Welcome to our Facebook Live seminar. It is our goal here to help you unpack the details of the latest COVID-19 legislation that both extends the Family Medical Leave Act as well as provides mandatory sick leave pay. There is a lot to unpack. There's a lot of questions, I'm sure. We will try to address your questions. You can either post them on our Facebook page during this presentation, and I'll try to address them as they come up, or you can email them to our law firm privately, and we can address them that way. So why don't we get started? This is a national bill, so this affects all employers across the country. I'm not going to be addressing specific state considerations, both in California and Florida where our offices are. There might be specific state rules, but for purposes of this, we're going to be covering three things. What the Emergency FMLA Expansion Act covers, who it applies to, and what employee rights are expanded. Second, we're going to be covering the Unemployment Compensation Stabilization Access Act. It's very simple for employers. It's just a notification requirement. And third, we're going to be talking about the Emergency Paid Sick Leave Act. If you are listening and your employment is regulated by a collective bargaining agreement, or you are a union listening in, please note that there are specific sections of this new law that apply to you that are not going to be covered in today's webinar in order to try to keep it under 30 minutes. We will be doing a union segment coming up soon. Okay, so let's talk a little bit about the Emergency FMLA law. Just by way of background, the Family Medical Leave Act was signed into law by President Bill Clinton in 1993. When it was enacted in 1993, it only applied to 50 or more, 50 or more employees, and it basically provided unpaid leave time and a guaranteed position back when you return from leave as an employee. So this amendment creates an emergency act which creates additional leave rights. Some very important hallmark provisions of this bill is it applies to all employers. If you have one employee, if you're the only employee, it applies to you up to 500. So there's also a sunset provision, which means the law takes effect April 2nd, next week effectively, and it ends December 31st, 2020. So who is covered as an employer? Anybody who has less than 500 employees is covered. Why large employers are not covered is a good question for Congress. Unfortunately, I don't have any I don't have any information on that. But if you have 1 to 499 employees, you need to govern yourself as if this law applies to you, because by the text of it, it does. Now, there are exemptions. The exemption that is listed in the act itself is healthcare providers and emergency providers are relieved from responsibility under the act. Businesses that have less than 50 employees could be exempt. And I say could, it's not an automatic exemption. It could be exempt, but they need to apply to the Department of Labor and demonstrate that complying with these laws would jeopardize the viability of the business. There is zero guidance on what that means. There is no procedure to apply for that waiver as of right now. And this is a very analogous situation to what we saw in the Affordable Health Care Act arena, where the waivers came out many, many months, if not years later. And so for purposes of compliance, until that happens, until the Department of Labor comes out with a way for businesses to apply and be approved for an exemption, this law does apply to you. So what does it do? Okay, part one is it requires leave. So remember I said it amended the Family Medical Leave Act, which was in 1993. It adds this new section, Section F. And basically what it says is that during the period beginning April 2nd to December 31st, 2020, because of a qualifying need related to a public health emergency, employees will be entitled to take leave. And they will be entitled to take not just unpaid leave like the FMLA provides, but paid leave. So let's break that down. Part one is, what is the definition of a qualifying need? And here's the language directly from the statute on your screen. Basically states that a qualifying need relates to a public health emergency if the employee is unable to work or telecommute or telework due to a need to care for the son or daughter of anyone who's 18 years of age of that employee if that school or daycare has been closed. So it's really interesting language here. That means that in order to qualify, an employee does not have to be sick, but has to be required to stay home with a minor child. That is very different. It's very broad. So interesting question. As with all new legislation, there are questions raised and there are questions answered by the legislation. One of the biggest questions in my view is, what if you're sick with the COVID-19? Is that a qualifying condition? Because generally speaking, if you have mild symptoms, it's a cold for most people, that would not qualify for FMLA leave. But if you have a more significant healthcare condition, hospitalization, or you have to treat with a doctor, or asthma is flared up, then that could qualify as an FMLA position, qualifying leave. But under this provision, the emergency statute, if you have employees who are going home because schools are closed or daycare is closed, even if they are not sick, they would qualify for leave under this particular statute. So how much leave do they get? That's part two. Who qualifies? And then second is, well, how much leave do they get? So the first, and whether or not it's paid. So let's talk about whether it's paid. The first 10 days are unpaid. And if that employee happens to have accrued paid time off or accrued sick leave under your current policy, then the employee would be able to use that if they wanted to. And that's at the employee's election. This is another distinction. In the FMLA case law to date, it's typically mandated by the employer that you must use PTO leave. And so this is at the employee's election. So the employer can choose to substitute the first 10 days of unpaid leave with any vacation, PTO, or sick leave that they have. So any employer shall provide for paid leave for each day that an employee takes after those first 10 days. So day 1 through 10, unpaid, unless the employee elects to fill in their vacation or PTO. The next 10 days are paid, right? So the employer can pay, but they only have to pay 2/3 of the regular salary. And in no case shall the sick leave pay should never be more than $200 a day or $10,000. FMLA typically allows for 12 weeks of unpaid leave as it was originally enacted. This amendment says that it's 10 weeks if an employee has to stay home to care for someone whose school has closed, and they get up to 10 weeks of pay at $200 per day, up to a $10,000 aggregate. So 200 times 10 weeks is 10,000. That's how we get to that. So that's how, so up to 10 weeks if the school remains closed. Now, at any time during the leave, if the employee can return to work, or they no longer become the primary caretaker of someone who's home, they would no longer be qualified for that leave time. So here's a little chart to help you just kind of digest what I just said. For just the FMLA portion of the bill, we're going to get to paid sick leave as a secondary part, but for phase one, the FMLA expansion, day 1 through 10 unpaid unless the employee elects to fill in their paid time off. Thereafter, the employer can pay $200 a day or 2/3 of their salary for up to 10 weeks as long as they're qualified for that particular type of leave time. So it's going to be expensive for employers, no question about that. When the bill was enacted in 1993, one of the hallmark principles was the right to reinstatement to your position. This extension also has a right to reinstatement. That means employers must hold the position for that employee who's out. And they must hold that position provided and be restored back to a position that is equal, right? So it has to have equivalent position with equivalent employment benefits pay. So you can't bring someone back and demote them, bring a salaried employee back and place them in an hourly position, put a management employee as an hourly non-management worker. That won't work. So the employee has a right to reinstatement just like they would under the FMLA. There are a few exceptions. Employers who have less than 25 employees do not have to honor that right of reinstatement to the employee when they're returning from their leave time. And they have that right of reinstatement, that exemption for smaller employers up to 25 employees applies if all of these 4 conditions are met. It means here are the conditions. Number 1, the leave time has to be taken during this coronavirus outbreak, essentially now to the end of the year. The position has to no longer be available, either because of economic conditions, because the company has changed its operating conditions. I think the best example of that would be if you closed a particular department because of this outbreak. Third, the employer has to take reasonable efforts to restore employment in other positions. So if a department closes and another position might open up in a different department, you have to notify this employee of that particular opportunity. Fourth, you have to take efforts if the position does in the future come available. This is very novel. So that means if right now you close your department, but then in 6 months that department reopens, you may have an obligation under this particular bill to reach back out to that employee who lost their job and wasn't given reinstatement and say that position has now opened up. And so an employer has to take reasonable efforts to reach an employee within 1 year of the date the leave ended or within 12 weeks from when the leave began, whichever is earlier. So we have to do those calculations. And so just to recap, no employer has to reinstate an employee if they have less than 25 employees and they've met the conditions of the statute. This is complicated stuff, and we recommend that you get advice from a board-certified labor and employment attorney or competent labor and employment attorney who is in your state. So another point, another nuance, if the employee has noticed that they're going to be on leave or they need to care for their kids. For example, if today the employee learns that in 2 weeks their daycare is going to close, the time to give notice to the employer is when it's foreseeable. So the employee would have to give notice, as much notice as practical. In my example, they should tell them today, hey, I just learned that my daycare is going to be closing in the next 2 weeks. All right, that is pretty much it for the Family Medical Leave Emergency Extension Act. It's pretty significant, but now let's move to the Unemployment Insurance Stabilization Law. And this simply is a very easy thing to comply with if you're an employer. At the time that you separate an employee under this law, all you have to do is notify the employee of their right to unemployment compensation, but you have to do that at the time of separation. So that just means that you need to give the employee, notification when you separate or lay them off or furlough them that they have a right to go get unemployment. The statute gives much money, and a lot of robust legislation is going into unemployment compensation. So unemployment compensation is regulated by the states. Money is coming from the federal government into each of those states, and that's going to be seen how that's going to be regulated. But your small obligation is just to notify people that they have a right. So the Department of Labor is supposed to help us figure out exactly what it is that you're going to say to these terminated or employees who are being laid off or furloughed. We don't have that yet. So my suggestion and my recommendation here in Florida is to simply defer the employee to the floridajobs.gov website so that they know that that's where they can go and apply for unemployment, and they're likely going to get it. I realized that in going through the slides, I failed to mention the definition of an eligible employee under the FMLA. So I want to go back to that, and thank you for who just texted me to let me know that. An eligible employee to get that FMLA leave we were just talking about a moment ago only needs to have been employed for 30 days. So very important point. An eligible employee is somebody who is there for just 30 days, and then they have an opportunity to get paid leave up to 10 weeks at $200 a day at a maximum of $10,000 per employee. So that's pretty significant. All right, so now let's talk about Emergency Paid Sick Leave Act. This is the third aspect of the bill as passed, and this is separate from the FMLA. So we'll talk about at the end of this presentation how you apply all of those things in tandem, right? So this is just the Paid Sick Leave Act, Section 5101. And under Section 5101, an employer must pay sick time to any employee who's unable to work or remote work, telework as the statute refers to it, because of any one of the following conditions. Don't jumble up these definitions and apply them to the FMLA. It is different. That is one of the common things I've seen. A lot of the reporting on these two bills have kind of combined everything all together. So what we're talking about now is just who gets paid sick leave. This does not entitle them to necessarily to paid FMLA leave. This is just sick time. So here they are. Number one, if that person is locally quarantined or isolated because they think they have COVID-19. Number two, that if the employer has been advised by a healthcare provider to self-quarantine. If the employee is having symptoms of the virus and seeking a medical diagnosis. That's number three. Number four, if the employee is caring for an individual who is in isolation because of COVID-19 or has been advised to isolate or self-quarantine because of COVID-19. The next one is if the employee is caring for a son or daughter under the age of 18 whose school has been closed. And last, if the employee is experiencing any other substantially similar condition specified by HHS. That would mean if you were having some type of related healthcare condition that might be secondary to COVID-19 and you need to self-quarantine or you need to be home, you would also be entitled to this paid sick leave. So if you meet any one of those criteria, then the employer must pay sick time. Some employers, just like under the FMLA, might be exempt, but those exemptions are not codified yet, other than to say that emergency responders and healthcare providers are going to be exempt. That's all we know. So how much do you pay? If your employee is a full-time employee, the employer must pay 80 hours of sick leave for all full-time employees. For part-time employees, the employee has to take an average. So they're going to pay that employee a number of hours equal to the hours that they worked on average in the prior 2-week period. So it just varies. So full-time versus part-time. Paid sick time is going to be capped as well. They're going to get an increment compensation, but it's never going to be more than $511 a day, or a total of $51.10 in aggregate. Right, so that's how that works. So there's certainly a cap on that. And the paid sick time is going to be, that cap is going to apply to those situations that are available on your screen. So that means that there's $511 per day is due, $51.10 in the aggregate. If the employee is subjected to a federal, state, or local quarantine or isolation, if the employee has been advised by a healthcare provider to self-quarantine, if the employee is experiencing symptoms themselves, they get $510 a day paid by the employer under those situations. Or, and this is important, if the employee is out to care for someone, like their son or daughter who's home sick, then they get less. They get $200 per day and $2,000 per aggregate. So if the employee themselves is quarantined, isolated, or sick, they get the $511. If the employee's home to take care of a minor child, they only get the $200 per day or $2,000 in aggregate based on the legislation. So that's the amount of sick time. A couple of nuances and things to be aware of. Sick leave does not carry over. So if an employee is able to work remotely and just keeps plowing through, regardless of their own healthcare condition or taking care of any minor children, they don't get to bank that leave and then use it next year or after this crisis is over. That's number one. Second, the need for sick leave ends when the employee comes back to work. So said another way, the employee only gets the leave if they take it. So then in the second they come back, if they don't take all of it, then it terminates. The employer can't require an employee to find a replacement or to cover for them. So in restaurants and bars, they might say, sure, take the time off, but then cover your shift. Healthcare workers are having this too, although there's a question whether all of them are required to the statute, but the law makes it clear that you can't force an employee to find its own replacement. That's the important takeaway. Next, an employer may not require an employee to use their PTO under this part of the statute. So this part of the statute, meaning the sick leave statute, makes it clear that you can't tell an employee to use their PTO first. You can do that under the FMLA, you can't do that here. So you can't require that before paying them their paid sick leave. The sick leave has to be paid first, that's why we're calling this sequencing. So under the Sick Leave Act, the employer must pay the sick leave first, and then if the employee remains out, they can then use their PTO. All right, so in applying all these statutes together, it can be quite the challenge, right? So here's what we know. If an employee goes out due to their own condition and they're sick, they'll likely qualify for the FMLA if their sickness qualifies, if it's sick enough. They will automatically qualify for the FMLA extension if they're home to take care of their small child or their small child's school has closed because of COVID-19. And that scenario, they go immediately on FMLA. They get the first 10 days unpaid. Then they continue to remain out on leave if they qualify for up to 10 weeks, and they get paid by the employer up to $200 per day. Separate from the FMLA leave, the Sick Leave Act says yes, and they're going to get 10 days of paid leave, which in theory they can use for those first 10 days if they want to. Complicated stuff here, guys, understood. So please feel free to email any questions or comments so we can ask them. If you're probably going to need to take a look at your policies to make sure they're revamped, because I'm quite certain that in the 21 years I've been practicing as a board certified attorney, we've not seen anything quite like this. It's complicated stuff. Another obligation that the employer has to do is they must give notice to all their employees. They need to post the notice in a conspicuous place about these new rights. Good news, the Department of Labor is going to issue a draft notice Typically, the Department of Labor does that in every language, Creole and Spanish for Florida, which is very important. As an employer, you have the obligation to post it in each language for your employees to understand. Your duty is to post it in a conspicuous place. That can be near the employee time card, the water cooler. This is kind of an ironic requirement at a time that we're telling people to socially distance and not come into work. So I think you can meet this requirement best in these times by just emailing it to all your employees or putting it up on an employer intranet, website, chat, Google Chat, whatever it is that you use to communicate directives to your employees, even if that means texting them the notice. The notice is due out on Thursday of next week, so stay tuned to our website and our Facebook page for examples of what a good notice should look like. All right, so some things that are prohibited under this statute, or on the sick leave statute in particular. It's unlawful for anyone to fire, discipline, or take an adverse employment action or discriminate against an employee who has taken leave in accordance with these laws, or who has filed a complaint or has threatened to file a complaint or testified about the things that we're talking about. So in simple, don't retaliate against your employees for taking time off. It is challenging for employers to maintain their businesses in this climate, but let's not add to that by firing people because they've taken advantage of the sick time. That's going to be considered a prohibited act. And since this law amends the Fair Labor Standards Act, there's going to be a way to get robust damages and enforcement of those violations. So an employee, in theory, can sue for termination for wrongful discharge and would be entitled to, for willful violations, they'd be entitled to damages. The FLSA provides for not only back wages, but also for double damages. They're referred to as liquidated damages, as well as attorney's fees and costs. So if you take a look at Section 2 that's up on your screen, employers can be subjected to penalties as described in Section 16 and 17 of the FLSA, which is what I just said, back wages, double damages, as well as attorney's fees and costs. So this is going to get costly quickly for the employer who acts with a knee-jerk response as opposed to a well-reasoned decision for terminating employees who have taken advantage of their sick time. So be careful. The Act also states that nothing in the Act will be construed to diminish any rights that you may have under the existing employer's policy. So, for example, if your employer provides a more robust paid time off policy, that is not supplemented or trumped by the Act. But if the policy does not provide the minimum requirements of this statute, for example, 10 days of paid sick, then those would need to be required. So that's interesting and something to keep in mind. So employers out there, you absolutely need to revamp your policies, and I have some practice pointers too to go through with everyone at the end here. You're definitely going to want to stay tuned to post that mandatory notice, and most importantly, you're going to need to communicate with your employees about why they're going out, the reasons for their leave, and keep good records. As always, employers, the most important defense and employment claims is keeping good notes and records about what's happening. And sometimes that can get lost when we're dealing with these emergency situations like we're dealing with now. So you might be asking yourself, how are employers going to pay for all this sick leave and FMLA paid leave to stay home and take care of a loved one? Well, they get a payroll credit. So the next couple of slides are going to walk through how the employer gets that payroll credit. So employers are going to be allowed a 100% payroll credit for all qualified sick leave wages that they pay within the calendar quarter. So this raises a couple of really interesting questions. One is, so as you all may know, an employer pays quarterly taxes, right? So they're going to file their first quarterly reports are going to be due at the end of the first quarter, which ends March 31st. And so in April, they're going to be filing a 941 return and paying their payroll taxes. If they've paid any qualifying wages, they will get 100% tax deduction for that. A couple of nuances, and be glad you heard it here first. This law doesn't take place until April. So employers out there who are trying to become compliant may want to hold off on paying sick leave, or may want to at least look at this closer until it becomes April, because there's an argument here that these tax credits, these payroll credits, might not come into effect until after the second quarter begins on April 1st. Just a little practical pointer there. Payroll credit for sick leave. Here's what the regulation actually says. It says that there shall be allowed a credit against the taxes imposed, these are payroll taxes, for each calendar quarter in an amount up to 100% of the qualified sick leave wages paid by that employer with respect to such calendar quarter. That's a lot of tax mumbo jumbo for sure. I'm not a tax attorney, but plain English would tell me that if it's during the calendar quarter, this is the first quarter, the law doesn't take place until the second quarter, it might be prudent for employers to start making these payments beginning after April 1st. You should consult with your tax attorney and your tax preparer just to be clear about your rights and remedies under that. Also, and this is interesting, a good question for your accountant, the wages that you pay under either the FMLA expansion or the Sick Leave Act are, quote, not considered wages under the Internal Revenue Code for purposes of Section 3221A. So if I'm reading that correctly, and again, new legislation often brings with it as many questions as it does answers, but if I'm reading that correctly, then that would mean that employers are relieved from payroll tax obligations at the same time they're getting 100% tax credit for the wages that they pay. Let's walk through an example. If starting in April, an employer gives $2,000 of sick leave pay to their employees during that quarter, when they go to file their quarterly report for the second quarter and they owe $2,100 in payroll taxes by their calculations, they get 100% credit, $2,000, for what they've paid as sick leave time. And that sick leave time that they've paid does not then incur wage taxes too. So that is how this is going to be paid for, which is an interesting way to do it. I don't think anyone has seen anything quite like this before. So there's probably going to be a little bit more legislation on it. As a point, practical consideration is what I've already said. Employers might want to hold off on doing anything into making any of these payments until April, because again, the law doesn't take place until April 2nd by its own language. Second, if an employer is looking at a layoff, is looking at terminating employees or doing a reduction in force in order to survive this economic crisis, and they might be considering offering severance. Some consideration should be given as to whether paying severance or family leave or paying sick time might be more advantageous to that employer and to the employee. That might result in more money in both of their pockets. So something to consider together with your labor and employment attorney. It may very well be more advantageous to pay the employee sick leave versus severance payment from a tax standpoint once the law is in effect in April. Another practical consideration is one thing that is clear under the law is that if you're able to work remotely, you don't qualify for either of these two laws. If you're physically capable of working, you're not sick, and you can telecommute, you can work remotely, for example, you don't get this time off. So a lot of employers would be well advised to, if they haven't already, to immediately start converting their workforce to some type of remote working situation. There are some interesting issues that arise with that, and I'll just run through them quickly in the interest of time. First of all, you need to have a policy that explains where the remote data is going to be stored. So if you have client data being stored on your employee's personal laptop computer, that's an issue for attorneys out there, because we know that we're responsible to maintain the integrity of our client data. So you want to have a bring your own device policy that says to the employee, it's great that you're working from home, we give you permission to use your personal home computer, but you need to let us install this software so that we can come wipe that computer clean, so that we've met our obligations to protect the data that's on that computer. You want to make sure that you have a policy and an understanding with that employee whether this remote working situation is temporary, which I would recommend, and it's clear that it's only as a result of the coronavirus situation, because what it could do if it isn't temporary is it could create a pattern that for the future employees might say, well, I can work remotely now, I did it during the coronavirus outbreak, and now it should be an accommodation that's offered for all purposes. So that discussion should happen with an employee, because it could raise ADA accommodation concerns later on down the way. A lot of remote working is done hourly because some employers feel like they don't have a handle or control on what's happening in the environment, and that's fine. You can change an employee from salary to hourly as long as it's done, communicated to the employee, but also give some consideration to the fact that a change like that might change that employee's status for overtime purposes. So like with all major employment decisions and changes, you should understand that it's kind of like pulling the thread on a sweater. It unravels a lot of different issues. So if you're going to go to remote working, which is a great idea, make sure that you have a clear communication and guideline with the employee, whose computer is going to be used, how the data is going to be maintained and cleaned if necessary. Make it clear whether this is a permanent or temporary accommodation due to the corona outbreak, and limit it to that, and make sure everyone has an understanding as to how many hours a week this employee is going to be working and whether or not they're exempt or non-exempt. And as always, you'll hear me say this many times, keep track of the hours contemporaneous, keep regular records so that it's very clear when an employee starts and ends their workday. A lot of software out there allows employees to clock in and out on smartphones. I know we use a product called TimeSoft. It is critical that you have accurate, contemporaneous time records for all employees, but particularly important for remote workers. One final point on remote workers. If people are leaving the state to live elsewhere, maybe to be with elderly parents or to be with different family members, to be together during this crisis, that's fine on a temporary basis. But if that remote assignment becomes permanent and that employee actually starts to reside in another state, that's going to raise other remote working issues, like, are they now a resident of, say, Montana, where you might need to comply with Montana's overtime laws or pay payroll taxes to Montana, or have workers' compensation in those other states. So just be aware of that. All right. How do we handle sick employees? This is just a practical consideration. I was getting a lot of emails and text messages about someone's come to work with a cold, half the staff is freaking out. Well, the best advice I can provide is to follow the CDC's recommendation, which is everyone should act as if they have the virus, which means don't come in contact with anyone, practice social distancing, minimize the number of employees in the workplace, and make sure everyone is a minimum of 6 feet apart to keep everyone safe. A lot of people have policies that allow kids to come to work with them. Obviously, the more people you come into contact with, the more likely it is that you're going to get the virus or you're going to share the virus, even if you're not symptomatic. So I would sort of frown on those policies right now. Talking points for managers are, if you have a cold or cough or act sick, you need to go home. And that's not because you can't do your job or you're not tough. It's because we all need to be socially conscious right now, and have a moral imperative that we need to keep everyone well. And so if you can work from home, you should work from home. And that's the CDC guideline. I think all of us probably know that now. OSHA. OSHA is part of the Department of Labor. As many employers know that in addition to overtime, wage and hour, sick leave, paid family leave, they also have to comply with OSHA requirements. And like everything else, OSHA has some new regulations set forth as a result of this statute. And so OSHA record-keeping requirements require that employers who are covered, which is pretty much everyone, 2 or more employees, to log in if someone has contracted COVID-19. So the question becomes, is when does a person have to notify OSHA if they contract the virus? And so there are some guidelines on that. I've given you the sites. I'm kind of running out of time, and so I don't want to spend a lot of time talking about that, but you can certainly look at the OSHA guidelines here that are there. But in general, that's the guidance. Okay. So workers' compensation, this is the burning question. I am not a workers' compensation attorney, but I consulted several in making this slide, and want to thank Mr. Lou Pfeffer for his involvement and give his law firm a plug. He represents injured workers and has for a number of decades, is excellent. And so thank you, Lou, for your input onto this side. So is COVID-19 a workers' compensation claim? And the answer is, it depends, as everything else, right? So what does it depend on? It depends on whether it falls into the definition of the workers' compensation statute, and whether it's, quote, an accident, an exposure, like a noxious substance, or an accident, repetitive trauma, or an occupational disease. What does that mean? We don't know, but workers' comp tends to focus on the risk that a particular employee has because of where they work, right? It's a risk that's greater than those faced by the everyday population. And so the standard is, the issue with whether or not COVID-19 is going to be considered workers' compensation depends on whether it can meet that heightened standard of causation, particularly after the worker comp system change in 2003. And that high standard is outlined here. It says, an injury or disease that's caused by exposure to a toxic substance, including, but not limited to, a fungus or mold, is not an injury by an accident arising out of the employment unless there is clear and convincing evidence establishing that exposure to the specific substance involved at the level to which the employee was exposed can cause injury or disease. And so that's the rub, right? Whether an employee is going to be able to meet the standard by clear and convincing evidence that the level they were exposed was a result of where they work, essentially. And so I think that there is an argument that healthcare providers will be able to meet that standard, but that is very much an open question right now. And the statute, doesn't speak to that clearly, and this is not a subject of any of the amendments to my knowledge. And so my comments are ringing off the hook. Let me just see if there's anything. Okay, so a couple of points that have been asked of me just to kind of go through a question and answer session while we're still a little over time, but we have a couple more minutes. Remote work, the question's asked, can a remote worker still qualify for FMLA leave under the expansion if they're unable to work at home because they have small children? And the answer is yes, they can still get paid if they're unable to work because of children. And so that is an important distinction for individuals to make. I think I'm pretty much out of time right now, but I thank everybody. If you have comments, I will log in just a few minutes to respond to them directly on the Facebook Live page. I know there's a lot here to know. Just a quick summary. Employees, even if they're not sick, who have to be home to care for a minor child whose school has closed as a result of COVID-19 is eligible for up to 10 weeks of paid leave. That is a huge change in the law and something that all employers need to plan for if they have less than 500 employees. I know we're hearing a lot of chatter about, well, I'm exempt because I have less than 50 employees. Potentially that could be the case, but until the Department of Labor creates a system by which you can apply for that waiver and be accepted, the law currently applies to you. So I thank everybody for the opportunity to speak with you. Our firm will continue to do all that we can to make sure everyone understands their rights and obligations under the statute, which I think is important to do. Thank you so much, everyone, and have a great afternoon.